And everybody introduce themselves, but we've got 10 meetings this year before turnaround and a lot of stuff that we've got to accomplish, including today. And so I am going to forego the introductions. I encourage everybody to say hello to the staff after the meeting and get to know our incredible team. We're glad to have them. Get to know each other. But we've got a lot of ground to cover in those 10 days that we get, and so we're going to kick right off. And the first order of business is request for bill introductions. Is there any bill introductions? Mr. Vice Chairman.
Yes, thank you, Mr. Chairman. Have a number of things to request. The first is 25 RS 0228. which regards the regulation of advanced voting ballot boxes by the Secretary of State. There is a RS 0364, which is about county commissions appointing county elected officials when there is a vacancy and there's no candidate for the office. There is another one, RS 0367, which is regarding timing of special elections. I have one at the on the benefit or for the bequest of Kim Borchers, former GOP National Committee Chairwoman, or Kansas chairperson. The RS 0268 about poll workers, about military personnel being okay to use even if they are not literally a resident of the district. I have three more, if you can hold on here. There is an RS 0114, which addresses the issues of a candidate seeking nomination by another party after having accepted the nomination for a party. We have a RS 0122, a familiar bill striking the 3-day post-election period for returning mailed advance voting ballots. We also have RS 0158, which would allow for a private online obituary notice published by the funeral homes to be sufficient grounds for removing a deceased person from the voter registration books. There is an RS, and my final one is an RS 0117, which would create the election crime of interference with an election official. And
are there any objections to these bills being introduced? Okay, seeing none, they'll be introduced by the committee. I have also a bill that I'd like to request introduction. It's 25 RS 0410. It creates a mechanism for the Department of Motor Vehicles to communicate with the Secretary of State's office to identify and remove non-citizens from the voter rolls. Are there any objections to this bill being introduced? Okay, seeing none, it'll be introduced. Are there any more bill introductions? Okay, seeing none, we'll move to our next item. So this is not on your agenda, and I apologize for that, but we're going to be talking about a lot of topics that we covered in the last biennium and in an interim committee meeting on campaign finance, and it's probably going to come up today. And so I've asked Elena Rutter, our incredible research expert, to give us a quick rundown on that committee.
Thank you, Mr. Chair. My name is Elena Rutter, and I am a senior research analyst with the Legislative Research Department. I am going to be doing a brief overview of this interim committee report from the 2023 Special Committee on Governmental Ethics Reform, Campaign Finance Law. So starting on the first page in the gray box is conclusions and recommendations. The Special Committee on Governmental Ethics Reform.
Very quickly, I forgot to mention this, and I meant to. All this stuff is on the S drive for this committee, and it's also uploaded on the KS Legislature website. So if you want to, we're going to try to remain as paperless as we can. So if you want to look at what she's reviewing, it's on the website and on the S drive. Sorry, please continue.
No worries. Thank you, Mr. Chair. So the first page of the report in the gray box is conclusions and recommendations from the committee. There Conclusions and recommendations were to address concerns that defined terms in the Campaign Finance Act were too vague. The committee recommended defining the term coordination, clarifying the definition of the term giving in the name of another or contribution in the name of another, and clarifying the definition of the term political committee or political action committee or PAC. And then the other recommendation was to address concerns that contribution limits were too low, and the committee recommended considering increasing contribution limits. As for the committee activities, on the bottom of the first page, on October 5th, we started with a presentation from Professor John McGinnis from Northwestern University Pritzker School of Law, and he gave us some guiding principles on regulating free speech, an overview of a few Supreme Court cases, legislative principles, and his 2 policy recommendations. The professor discussed arguments both for and against regulating speech in campaigns and elections. He gave an overview of Buckley v. Vallejo, the Supreme Court case, as well as a few other cases that were relevant to campaign finance law. He provided principles important for state legislatures to observe, such as independent expenditures should be unlimited, restrictions on contributions should be reasonable and take into account inflation and the changing of times. There should be a clear distinction between expenditures and coordinated expenditures, and laws should not be vague. The professor's 2 policy recommendations, the first was to structure laws, such as the definitions of independent expenditure and coordination, to be in tune with federal rules, and that was a recommendation of his because there's more certainty and less vagueness in federal rules, as they have already been litigated and fleshed out over years. And then the second recommendation would be to increase contribution limits, and it would help avoid polarization. Following the professor, the chief of staff for Governor Kelly addressed the committee and said that the governor supports promoting transparency and placing limits on campaign contributions. The chief of staff also discussed being open to increasing contribution limits and making contribution limits unlimited for political parties and putting protections in place so political parties do not influence primary races. We had a period of public comment, and there were 10 conferees who provided public comment, and then 2 provided written-only testimony. Generally, the 10 conferees discussed issues such as the definitions being too vague for PACs and giving in the name of another, discussing disclosure requirements for contributions and transparency issues, increasing contribution limits, and then personal experiences representing clients involved in ethics investigations, both in Kansas, nationally, and in other states. The executive director of the Kansas Governmental Ethics Commission provided an overview of the commission, information about investigations, the role of the commission, the makeup of the members of the commission, impact of disclosures on speech, and their legislative recommendations for the 2024 session. There was also a presentation on the second day of committee about free speech best practices from the chairman and president of the Institute for Free Speech. They provided information about how Kansas scores on their free speech index and how certain changes could affect their score. And then they also provided observations and recommendations to the committee. Some of those include that the major purpose test for PACs, in their view, is unconstitutional. The threshold for PACs was unconstitutional, and that a PAC definition is crucial to good campaign finance law. They also stated that disclosure thresholds and contribution limits should be increased. They also recommended indexing contribution limits to inflation. They said the coordination law is unclear under current Kansas law. They recommended repealing grassroots advocacy reporting and recommended avoiding regulating grassroots advocacy at all. And then another thing they said, it would help political parties by not limiting individual contributions. And then from staff, legislative research, and the revisor's office, there was an overview and history of the Governmental Ethics Commission, such as the structure, membership, and the name of the commission. There were presentations on the limits on campaign contributions, both in Kansas and in other states. And then the revisers provided an overview of House Sub for SB 208 from the 2023 session. And three major points of that legislation is it was a new statute governing the actions taken by the Governmental Ethics Commission. There is a 5-year statute of limitations on actions brought before the commission, and the commission is authorized to adopt rules and regulations concerning recusal of commission and members and staff. And finally, there was a presentation from KLRD about corrupt political advertising, and the executive director from the Ethics Commission also commented on that. And then the last page is the reiteration of the conclusions and recommendations. And I can stand for questions.
Are there any questions for Ms. Rudder? Okay, seeing none, you're off the hook. Thank you very much for that overview. Our next item on the agenda is welcoming Mr. Mark Skoglund who's the director of the Kansas Governmental Ethics Commission. Welcome to the committee. In the interest of time, I'd like to maybe 20 minutes comments, 20 minutes questions, so we can also get our other guest speaker up for the same amount of time, give or take.
Well, I really appreciate the opportunity to be here. Having only 10 meetings this year means that you should all be excited that you don't have to hear from me as much. So definitely appreciate the opportunity and the invitation. Real quick, 2 years ago, the legislature reviewed the Campaign Finance Act, made a lot of procedural changes, then discussed substantive changes in the interim committee primarily. I believe it's the intention of this committee to explore improvements to those substantive portions of the act that were not addressed in 2023. To that end, I've provided in front of you a fairly extensive overhaul draft with an indexed spreadsheet exploring the suggested improvements. In light of time, I will go through the ones that a lot of those are cleanup matters, but all of those have indicated rationales for the change, and I'm going to spend my time focusing on the big issues that were identified in the interim committee. When creating this, I did not generally seek to roll back changes from the 2023 legislature, but rather update any of those items where something may have, we've learned something in the last 2 years of living with those changes. The very first item I have, because it's the first statute numerically, has a suggested rollback, but otherwise I generally left items untouched or tweaked, intending to accomplish the mission of the legislature in 2023. So you do have a draft version of the actual text there as well, but I'm going to talk through the index because it's a little easier. But if you do want to see the text that's been drafted for those changes, those are also provided as well. So the first is the removing of the make sure that the Public Speech Protection Act does not by default apply to all actions of the commission, because we've learned it's impossible to investigate matters. You can appeal anything it's an interlocutory appeal, and we will never be able to investigate things because it takes more than 5 years to get through that process, which means that the statute of limitations expires. You can see there's other rationale for that as well. We preserved the 5-year statute of limitations. We think that's a great idea, but we added clear equitable tolling if the underlying act could not possibly be discovered due to fraud, we do have some instances where that has happened. There's no text for this one change. We want to add recalls to make sure that they're covered by the act. This is a gray area in the act, and we think that it deserves clarification. Coordination and contributions we'll talk about when we handle coordination at the very end. We added the express advocacy interpretation. We've talked about this a number of times in committee, and I know a lot of people, even many people here, have brought issues to us where something feels like it is express advocacy, and it's advocacy against you or for someone you know, but in reality, it doesn't meet those 9 phrases that are outlined in text. So we set a boundary that within 90 days of an election, if the only reasonable interpretation of a mailing or communication is to advocate for or against a candidate, that's the same as using those phrases. This is the federal interpretation. I believe this originally came from Chief Justice John Roberts in one of the opinions that he drafted. So it should be pretty well defended as well. We added some clarity for in-kind contributions. And on page 2 on the top, you get the first of the big issues from the interim committee, and that's redefining political action committees. So we redefine it we exclude campaigns, federal PACs, out-of-state PACs, inaugural committees, individuals, and in light of some comments we heard from other conferees as well, we also excluded married couples. who have the major purpose to expressly advocate for or against candidates, which means that over half of what they do are contributions or express advocacy. Now, what we've said before is that when you have the major purpose test, there are two massive issues. The first is, under what timeline do you evaluate that? Because if it's on a calendar year, then you have the election, and then we don't find out whether they're a PAC until December. And also, it's gameable. On December 31st, they could transfer money to an affiliated entity, and suddenly less than 50% of their expenditures are express advocacy. So it's easy to game. But also, the other issue is that it's unenforceable. If an entity simply asserts that they do not have, they've sent out mailings, they've done TV ads, but less than half of what they do is express advocacy, then we don't have an ability, there's no possible way for the commission to gain reasonable suspicion to investigate that matter, regardless of what the entity is. Reaching that threshold would be extremely difficult, even though reasonable suspicion is not a high threshold. So we tried to address that in a couple of ways. The first is borrowing from Virginia statute. Major purpose is judged on the life of the organization if possible, but especially for there's either entities that have been around for 30 years that don't have records that old, or brand new organizations. If it's not possible to evaluate, then you look at the previous 5 years, for which they certainly would have records. It also creates a rebuttable presumption that a group is a political committee, or that there's reasonable suspicion to believe that the entity is a political committee if an entity expends in excess of $2,500 in contributions or independent expenditures. This is some draft language. I think that addressing this unenforceability issue is a huge, huge barrier. I think this is one effort to get past this. It also creates an additional fine to try to deter people from gaming the system. For PACs that should register, do not miss reports so that the public is denied access to publicly available data. That assesses a fine of up to 3 times the total amount they expended on express advocacy and direct contributions to deter that kind of activity. That's for the PAC definition. To skip a line, on 4145, we allow for administrative terminations of PACs. We also do this for candidates as well. That you'll see when we talk about this later, that essentially if an entity goes inactive and we can't have conversations with them, they aren't responding to anything, but we think they're inactive. We don't want them to just keep receiving civil penalties. So we want to be able to administratively terminate them, which makes it much easier. This does include requiring electronic filing of reports for state offices. So I know that we've talked about this at length every year for a decade, but it is included in this draft. It overhauls in 4150 independent expenditure reporting pursuant to the interim committee report as well. So we increased the threshold from $100, which is where it is now, to $1,000. It clarifies the filing as clearly event-based, where you file it within 10 days of the expenditure. It unifies the statute with our practice, because the statute currently says that you use the reporting for any other entity, but that's not what actually happens in practice and has never been the practice of the commission. So at some point we should update the statute. So that's 4150 with the independent expenditure reporting. 4153, the contribution limit statute, it clarifies that sole proprietorships and single member LLCs are not treated as separate entities unless they've elected to be so. You have a little note on giving the name of another, but that's addressed in a separate statute. We'll talk about that in a minute. And it deletes the prohibition of PACs and political parties from using funds for federal candidates, something we've talked about doing and this committee has endorsed many times in the past 3 years. To 4154, which is the in the name of another statute, it includes, it's intended to include all the federal language and guidance. Now, I will tell you that giving the name of another, when you have a conduit, so you have an entity that gives money to an intermediary entity and directs that money to go to a final source, then at the federal level, the conduit actually has to report to the FEC that they've done that. Now, this draft does not do that, so it's actually weaker than the federal requirement, but it does say that if money is passed through an intermediary entity, it makes it very clear that what that means. It clarifies that the entity passing the money through must clearly indicate to the recipient who the donor was so that they can properly report it, and it also addresses reporting. So it is long. It actually includes most of two of the two federal regulations on point. We've talked in this committee before that it's perhaps best to have some of this in statute when we could address some of it in regulation, but statute actually is fixed by the legislature and is handled by this committee. So I think that that's generally the preferred option when possible, rather than having the commission handle these through regulation. 4156 is the paid for disclaimer statute. I have redrafted this. This committee has noted that, frankly, and I agree with the comments last time we've talked about this, it's not drafted great in terms of legibility. For a candidate reading that statute, I don't think could always necessarily know exactly, unless they're used to reading complicated statutes. I think that it doesn't provide the direction that I think that it should. So I've simplified it. It doesn't change a lot other than including text messages, but it is fixed a little bit. The 4157 on termination of accounts requires termination of inactive candidate accounts. This is a specific recommendation by the Ethics Commission, 6 years after the most recent term of office or 6 years after the last election they were a candidate in. This is because Kansas doesn't have a termination requirement, and we have accounts that have been open for 30 years. I don't know what is going to happen if those candidates ever decide to terminate their accounts, because there's no possible way that their bank records match up, and there's no possible way that the bank has those records to help them. So there's not a lot of solutions for us. So this is actually much more forgiving than Missouri and Oklahoma, who both have much shorter time frames. 6 years is just the current draft. Honestly, we would support any timeline as long as there was one at some point. At some point, you have to terminate your campaign account. It also provides for administrative termination, like we've talked about before. Now, on 4158, this is the subpoena statute that had a lot of revisions in 2023. The only two tweaks we would have is right now it says that we can't serve a subpoena until an application is filed in district court. The subpoena by statute already says that it's unenforceable unless a district court provides an order. We just want to be able to give it to them before we file the action to allow some opportunities for cooperation. We've had multiple people complain when we do have subpoenas that we had to file the district court action. So now they have to go file things in district court. They don't have an opportunity to have essentially a no-cost ability to cooperate. So we want to be able to send it to them before we actually file in district court. But it does still say by statute that it's unenforceable unless a district court says so. So it's just, in our view, that's a fairly technical change, but it allows the people who receive subpoenas to reduce any costs. We also remove the right to paid counsel, essentially, so they still have the right to counsel. They obviously can always have an attorney. That's always been the case. But the original draft and what's in statute right now is a little complicated because it doesn't say who pays for the counsel. It didn't amend other statutes that you need to amend if the intention is for like bids, for example, to provide counsel for these misdemeanors all of a sudden. Indigency is not defined. Counsel is already permitted by this section. So there's essentially one sentence that we're advocating removing. The 4161, we're asking for the ability to have summary hearings for failure to files. Typically, when someone hasn't filed a report and they've disappeared, there's not a factual dispute. And so going through a 45-minute long process of dealing with the full hearing process is a bit lengthy. The commission has indicated before they'd prefer the summary process that the Kansas Administrative Procedures Act already allows, but we need some statutory provision to allow us to do that in the first place. On the civil fines, we've kept the caps. We aren't advocating getting rid of the caps that were added in 2023. We've only added that if a violation is willful or wanton, which is an egregious threshold, it's not, then we essentially those caps don't exist. We aren't required to, right now we can only assess a fine of up to 3 times what one violation would be. But if conduct is willful or wanton, that cap goes away and we can assess $15,000 per violation. That doesn't happen a lot, but I will say I've had a number of conversations with people who the end of the conversation is, I don't understand why I don't just pay this fine. This is just a business expense for us. That means that our civil fine process is by no means a deterrent. We can't simply just be a business expense. The public has a right to this information. And last, I can see if I can do this in 7 minutes. I think I can. We're going to try to talk about coordination in 7 minutes. So coordination, everyone has a different approach to coordination. And so we've looked at every jurisdiction that we've talked to a number of places. Last year or 2 years ago, we actually talked at length, I think, about the federal requirements for coordination, which a lot of that is in reg, it's in the CFR, but obviously we want to be handling this in statute. Trying to follow the federal rules here could be good. It does provide a lot of guidance, but this committee noted that it's pretty complicated. So in reviewing coordination laws nationwide, we found Minnesota as one that we thought was a fairly solid and simplistic approach. It addresses a lot of the issues that we really care about in terms of what coordination is, and it actually addresses some of the underlying matters of making sure that, frankly, people can read the statute and understand what it means, which is something that I think everyone should be able to do. Not every candidate is a lawyer. So we want people to understand what the statute means and allow us to provide lots of guidance for this. So on the pages 38 and 39 of the large draft, if you do want to look at it, it has a lot of categories of what we're talking about. It defines consulting services because that comes up quite a bit. And again, virtually all of this, I think all of this, is taken almost verbatim from Minnesota's statutes. They have a shared vendor where essentially if a consultant or a vendor provides services to a candidate in the last 120 days, then if they also provide services to an entity that's doing express advocacy for that candidate, then it's coordinated unless they've established essentially some policy where they ensure that they have a policy in place where they've firewalled it, that the people who deal with the candidate aren't interacting with the people who deal with the PAC. It means that an entity can work on both sides of a particular communication, but in order to do that, they have to have a written policy in place that is actually followed and is effective. This is pretty normal. These firewall prohibitions are how the federal government deals with it. It's how, though I think Minnesota's is much clearer and cleaner than the federal rules on this. And I think that in a lot of other states where firewall provisions create this safe harbor, essentially. So you can have your firm work on both sides of a coordinated expense without it being coordination, as long as they're not communicating with each other about it. Non-public information from a candidate also comes up. This is what we see a lot, where a coordinated expenditure is where the person who's making the expense receives from the candidate information about what they need, essentially. So if the candidate calls up the PAC and says, hey, I think that I really need some targeting on this kind of voter, and what they care about is this, according to what I've got. Can you do something for that? Or even without that last sentence, if the PAC goes and does that, they've done that. That is a coordinated expenditure. That is exactly what we're talking about here. This includes non-public information from a spender, which I thought was an interesting approach that is not everywhere, but Minnesota does have this, where essentially if the spender tells the candidate about the contribution, about the expenditure they're going to do before it happens, the candidate obviously is able to adapt their messaging as well. Usually you hear about coordination coming from the candidate to the vendor or to the spender. This is a good example of a limited instance where a PAC can't call up a candidate and say, hey, just so you know, this is the mailer that's going out in your district next week, and this is what it says. Here's the audience, so you don't drop your mail at the exact same time. Candidate participation is the last category. Essentially, if the candidate makes a request or suggestion for the expenditure, or if the candidate participates in the creation or development of it, or participates in the content, timing, location, audience, volume, or frequency of the expense. So if they're helping the PAC design the mailer, they really should not be able to be a recipient of the mailer. And it also has 9 things that are not coordination by themselves. A candidate asking a spender to not make an expenditure for their opponent, or to support, even if they ask them to make an expenditure to support them, does not on its own make a coordinated expenditure. A candidate providing to a spender names of donors is fine. An expenditure using public information is fine. There's 6 others that are isolated there as well, again, pulled from Minnesota, and I think this is a great example of a scenario where we should be isolating some safe harbor issues that people, so we don't get calls all the time about, well, PAC we want to put out this information, can we take this information or this picture from the candidate website? The answer is yes, it's publicly available information. So we clarify all of this in statute. and provide a number of safe harbors here as well. And again, coordination can only happen on an expenditure that is express advocacy for or against a candidate. So that's how this is handled. Now, I think I've hit 19 minutes. I can certainly take any questions if there are any. I can't imagine there are.
That was succinct and on time. Thank you very much. Are there any questions for Director Skoglund? Representative Penn.
Thank you, Mr. Chairman. Thank you for your testimony today, Mr. Skoglund. There was one that you were talking about. It was, I forget which page it was, and you were talking about $2,500 was a cap. Was that for contribution, was that $2,500 on the coordinated, was it coordinated contribution? Do you know what I'm referring to?
I know what you're referring to. It's the
yeah,
political committee definition.
Yeah, rebuttable presumption, any entity expends, page 2, top.
Yes.
In excess of $2,500 in contributions. Is that in total contributions that they are making to all candidates, or is it only $2,500 to a specific candidate?
It's $2,500 total is how it's written right now. But again, that's something that can be adjusted. This is just language that's intended. That 2,500 number is also something that we have plugged in there. We don't know where that threshold should fall. We think there needs to be some sort of enforceability of this. And without a rebuttable presumption built into the law somehow, I don't have another approach that allows an ethics commission to really investigate a PAC. Because otherwise, if I were a PAC, I don't see why they wouldn't just call up the ethics commission and say, yeah, less than half of what we do is political activity. Sorry, we do a lot of things. We'd never be able to enforce anything. I mean, it's categorically impossible. But I will also note, as an aside to your question as well, when you're talking about coordination, coordination isn't prohibited necessarily, it just makes it an in-kind contribution. So people who coordinate an expense with a candidate, they can do that as long as they stay under the contribution limit. It just makes that amount a contribution, which is how it's addressed everywhere in the country that I'm aware of, at least.
Any other questions for Director Skoglund? Okay, well, I've got a couple questions if you don't mind. So one of the other things that came out of the 2023 interim committee was contribution limits. And one of the suggestions was that if you were to remove the donation limits for parties, it would weaken the power of PACs. The contention being that the reason that PACs are so involved in our politics is because people can't give any more money to the party, so they have to go give their money someplace else if they want to participate. What is your, I'd like to hear your perspective. If we were to do that, do you think that it would really have that impact? Or, I mean, do you think it would make it worse? Do you think it would make it better?
I think that it's reasonably likely that parties would have a slightly larger influence in terms of where they are now. I don't know if they would actually eclipse PACs in terms of the influence that they actually have on an election, but I do think that the argument you make is, at least to some extent, correct. The concern that a lot of people have when we talk about removing the limits on party contributions is that for the same reasons that we have contribution limits for candidates, the public needs to believe that the public needs the ability to believe that candidates and parties are not simply bought by a few people, right? I mean, that's the purpose, or one of the large purposes of contribution limits, to believe that there's not some quid pro quo that's happening in some meaningful way. And I think that completely removing the contribution limits for parties, I think, has that effect, is I think the public would reasonably perceive that. I'm not saying anything about it being true or not, but that is probably the perception. That said, I think that it's been a long time since contribution limits were increased in a variety of ways, and I think most people that I've talked to and have that belief in the legislature, and I think that this would be a good vehicle to increase those limits as needed. So I do actually have, there's one, I think, a couple small changes made in this draft to the contribution limit statute. And so it's a good opportunity. If you think that contribution limit should increase, that'd be a great place to work in the number that you have. I almost left the number blank on this draft.
Giant question mark with a highlighter pen. So I'm shifting gears on you rapidly because we don't have a lot of time and there's a lot of things I'd like to ask. But
I did policy debate, I'm good.
Every day I discover new things that the Secretary of State's office is involved in. And yesterday I found out that they issue the lobbyist badges. And there are already, like, you go to the Secretary of State's website to do your campaign finance reporting. What would it take, and would you be in favor of moving all of those functions out of the Secretary of State's office that are clearly related to campaign finance and to, kind of public assurance of integrity in our system, and move them to your kind of your website and your facility and your domain?
Yeah, so at the outset, I want to make sure I answer your question, but quickly I want to make sure to note that we always love working with the Secretary of State's office. Their staff is excellent. I know Clay was behind me, and we always like getting to work with him. Yeah. So we're very lucky when we get to work with him, and I'm not saying that just because he's here. But the rest of their staff also are really great. But I will note, we don't oppose having some of those responsibilities transferred to our office. I'll note that's a lot. That's all campaign finance reports, that's all lobbying reports, that's all PAC reports, anything like that, lobbying badges. They're the repository of records for all of that. And so I don't oppose that, but we would need the budget to handle it because it's a lot. I think that we would need a vendor to handle an electronic campaign finance system, just because I think the legislature broadly has asked for that anyway. And if we're transferring responsibilities to our office, that would be one thing we could do. It's pretty costly to do that, but it's a primarily it's a one-time expense at least, so that's something. We would need the staff to handle it. We have 8.5 people in my office, and everyone has their own responsibility. I have one SSI coordinator. I have one state campaign finance coordinator. I'm very lucky to have the staff I have, but they definitely cannot handle all of the reporting, receiving requirements or regulations as well. So, yep, I'm happy to have those conversations. I don't oppose that at all, but it is something that couldn't be an unfunded mandate for sure.
Okay, and I've got one other question that also came from the commission, or the interim committee. The name of your organization is the Kansas Governmental Ethics Commission. Is it unethical to forget to put the treasurer on your mailer? Or, do you think that, how would you feel about a name change to something that says something more like campaign finance and less like ethics? Because there's a stigma, right? When you get subpoenaed by ethics, that sounds a lot different than being subpoenaed by the Campaign Finance Oversight Commission or whatever.
Yes, and my position hasn't changed from the interim committee. I obviously like the name we have just because it's the most common structure of a name, but there's lots of good names out there. I mean, not to borrow from California, but the Fair Political Practices Commission, I understand, but Fair Political Practices Commission, I think, has a little bit less of a sting than the Ethics Commission. I mean, I understand the concern, and we've had a lot of name changes. We'd survive another one, it'd be okay. I don't have a position on it, but I'm happy to have those conversations if you want my input on them. But I think that as long as people can reasonably identify what it is we do, I think that the name is fine.
Great. Any other questions for Director Skoglund? Okay, seeing none. Thank you very much for your time and for.
I think I'll see you again, but I appreciate it.
Hey, thank you. All right, our next conferee is Josh Nye from Krieghauser Nye Law Group. Welcome back to the committee. Thank you for taking the time to talk to us.
Thank you, Mr. Chairman and members of the committee. Glad to be back here. It's been a couple years since October 2023. I was in the interim committee. For those who don't know me, I'm a partner with the law firm aforementioned. My partner, Ryan Kriegshauser, is behind me. And I'm also an elected county attorney separately from the firm. So I've been in your shoes for many years regarding having to comply with these laws myself, as well as representing clients across the state over the past 16 years related to campaign finance and governmental ethics issues. I think I'm still one of only 2 attorneys in the state that has actually recently tried a federal trial related to the Campaign Finance Act, in State Finance Act. In 2019, there was a federal trial wherein the Department of Justice took the Campaign Finance Act regarding $10,000 worth of expenditures and filed a 26-count superseding indictment, and we had a week-long jury trial down in Wichita in front of Judge Melgren. And so that was kind of my reawakening, so to speak, after serving as a securities commissioner and being an agency head or serving as part of an agency head of 2 administrative agencies and applying CAPA and other types of procedural rules and substantive rules that go into appearing before the Governmental Ethics Commission on a regular basis. And that federal trial ended in an acquittal. But that wasn't the end of the story, unfortunately. After years of being subject to wiretap notices and subpoenas and search warrants, my client, a few years after that acquittal, got notice from the Governmental Ethics Commission that the exact same fact pattern was now being brought to in a complaint that had dozens, I think over 40 counts from the Ethics Commission regarding the same transactions, the same issues. So we had to go back kind of into that experience, but now in front of an administrative agency in the state of Kansas to relitigate. At that point, my client was out of money. We signed a consent order at that time because there was no money left for attorney's fees after a week-long federal trial and three-year investigation. And so I really do have a soft spot in my heart, not only personally, but also on behalf of my clients, dating back at least most recently to 2018, 2019, that these laws matter. This is the one agency that regulates a core fundamental constitutional right of yours. It's a regulatory bureaucracy that regulates First Amendment conduct. Just let that sink in. I mean, we saw earlier in the interim committee the idea of regulating free speech. And there is case law. Professor McGinnis, who I helped lined up to just be an expert in that interim committee report, was very helpful in just kind of giving a nationwide viewpoint of how the interaction between the Constitution and this particular area of regulation works on a regular basis. And there are constantly case law updates from SCOTUS, from the circuits, federal circuits around the nation, Supreme Court in Kansas, and less frequently in Court of Appeals and district courts here. But there has been a lot of activity in the last several years, unfortunately. In 2023, on the heels of what I consider to be one of probably the most unprecedented in terms of scale and scope and the amount of people that received subpoenas in 2022 during session, shocked that there were all these kind of flying around the Capitol with that ethics tag. At that point, my law partner and I engaged in this refresher investigation, so to speak, but it kind of put the federal case to shame at that point regarding the scope and the amount, the breadth of the amount of information that was being sought by this administrative agency. And we told them at the time, we think that your actions are blatantly unconstitutional. We think it's overbroad. But there weren't a lot of procedural mechanisms to even challenge these things. It really was Alice in Wonderland. And at the time of trying to get through to this commission at the time to say, what you do is chilling First Amendment conduct in Kansas, especially how you do it, whether you use a sledgehammer or a scalpel. And they had chosen and have chosen over the last several years to use a sledgehammer in a lot of these things instead of a scalpel. So there's kind of two laws, sets of laws, so to speak. And that's what's on paper, what's been on paper since the 1970s. Occasionally has been updated during the long tenure of former Executive Director Carol Williams. In my federal trial, she was my expert witness on behalf of the defense, saying how hard it is to comply with these laws and how everyone's just trying to do the right thing. And I asked her about the saying at the time in that trial in front of the jury, what does call Carol mean? And Carol Williams shared, well, it's kind of a going saying in the state of Kansas. And when you got a question, you want to work something out, you want to make sure you're doing it right, you just pick up the phone and you call Carol. That was the way that people did it, because you've got these broad statutes that were adopted in the 1970s, many of which have not been updated since then. And when you're trying to figure out what conduct is covered and what's not, there was just kind of this, we're going to treat you right, and if you call up Carol, she'll at least tell you what to do, what not to do, and then just paper the file so that you've got some sense of, well, I went down this road and I wasn't trying to break the law. Over the past 7 to 8 years since her retirement, things have shifted. There is a culture of fear in Kansas, a culture that not just candidates, not just practitioners, I'm stupid enough to get paid to actually pick up the phone and call the Ethics Commission to ask what we should do on something like this, but also lobbyists. They won't come and testify in front of this commission because, as the chairman mentioned, there is a stigma to popping your head up. As long as the eye of Sauron is not on you, we're not going to say anything. But I've been paid over client after client after client after client that when they get that nasty summons, when they get that nasty subpoena, to actually engage and litigate this. And it really has been Alice in Wonderland. So my testimony is 2 pages. And it really is just a refresher. Some of you were around in 2023 when we had quite the brouhaha, so to speak, over a lot of provisions that procedural and substantive that needed to be updated at that point. But there's been a lot that's happened since Senate Bill 208 was passed and signed into law by the governor in 2023. I believe that actually has made the commission better. Maybe reluctantly on their part, but it has made it better because there's more checks and balances, there's more due process. I'm happy to go into that type of stuff during questioning, but it really is my opinion and my partner's opinion that practicing in front of the commission and courts since February 2023, or at least since the law was passed later, is now fairer and a more just process. And then we had the interim committee. We're a bipartisan, unanimous committee of this legislature made up of senators, representatives. In October, Republicans, Democrats came together and unanimously said these 3 statutes are vague, are ambiguous. We don't know what they mean. I'm telling you as a practitioner, I don't know what they mean. And like I said, there's kind of 2 sets of laws. There's one that's on paper, and there's the other set of laws that are not in any regulation, not in any statute, not in any advisory opinion, but they're in the mind of the staff, the prosecutors at the KGEC. And what is obvious to them is not obvious to me. It's not obvious to my clients, and these are bipartisan clients many times, where we're just trying to figure out what the law is. So we can either try to get it in writing through an advisory opinion, or just an email would be good, of what does this law mean, or we can just keep our head down. Well, after that committee made those findings, the legislature didn't take any of the recommendations up last year. I don't blame you, it's an election year. You don't want to be arguing with ethics when you're trying to get reelected. But after that, my clients had enough. The Fresh Vision OP that testified in February of 2023 on House Bill 208, or at the time House Bill 2391, which I was heavily involved in drafting, that many of those provisions eventually made it into 208. They testified, well, they eventually decided to sue in federal court. And just a few weeks ago, January 3rd, a federal judge finally said the same thing we've been telling the commission and you guys for years. This statute, as it's being applied, in that case the PAC statute, is unconstitutional. You cannot try, and this is a big deal, just to go into one little issue. The major purpose test, or a major purpose test, is a big deal. If you set up a PAC, or if you set up a 501c4, and you don't intend on engaging in a lot of express advocacy, but you may send out one mailer. Well, under the current law, with a major purpose, one of many major purposes, which is out of sync with 10th Circuit case law, if the commission decides you're a PAC, that means every single donor that gave to that 501c4, the veil is pierced now. Every single one becomes public information. This is what Bonta was about in California. That went all the way up to SCOTUS. Similar types of things. End around ways of getting information that the First Amendment protects into the public sphere. So it's a much bigger deal on some of these things than just, well, why can't you just file the report? Well, we're trying to help our clients plan in such a way that actually allows them to avail themselves of their First Amendment conduct and decide how they want to approach their speech. And so that not only did that happen in January of 2025, where we actually won, and I've hyperlinked in my digital version of this to the federal district court. But earlier that year, earlier in the fall, August 2024, we won on a completely unrelated investigation in Shawnee County District Court, where the giving in the name of another statute was ruled unconstitutional as applied by this particular staff. So again, we have two completely unrelated investigations, two completely unrelated statutes, and now we're finally showing in the judicial branch what we've been pleading with you for years, which is there's something amiss here. And that I think that it's all well and good to write laws that are clear, but I don't want to have to write laws out of paranoia. I don't want to have to write laws in such a way to say, how could this possibly be misinterpreted? Because there isn't a rule of lenity. There isn't a reasonableness factor test here. It really is being caught off guard, and it's a making law by enforcement and by gotcha. And so I was asking myself, if asked by the committee, what do you want us to do about it? What I would say. And I think that this is a bipartisan discussion that needs to be very methodical. There's not one way to do this. I certainly wouldn't copy California or Minnesota as my first states that I'm going to do it. I think you're going to hear from national experts when you have bills in front of you on various issues and whatnot. What I wanted to spend my time on today is just to say that there is something structurally broken. And when asked, what do I want you to do about it? I would like you to think about, is this the one way to set up regulation of First Amendment conduct in Kansas? Is there a reason that we're continuing to do the same thing that we've always done, even though this has kind of gotten flipped on its head over the past 7 years? And I think the answer is no, you don't have to do it exactly the way you've done it since the 1970s. And frankly, there wasn't a problem before, but I'm telling you right now, there is. And the last thing I'll mention is that as a result of those victories, and there was even for us in court, there was even a case that came out today on a similar giving in the name of another case that the same district court judge struck a subpoena for someone represented by another firm. And hopefully you'll hear from those firms this session. Hopefully you'll hear from other practitioners from those people as well. But each one of those cases, there are at least 4 pending. In our August case in front of Shawnee County, we were awarded $85,000 in attorney's fees. In this case that came out today, the very similar fact pattern, same legal result. It was struck under the Public Speech Protection Act. That is likely going to have attorney's fees. Our motion for attorney's fees in the federal case is due this Friday in federal court. And then if it goes up on appeal, it'll be pending appeal, but every single one of those appeal billable hours for our clients will be subject to the state paying if we're ultimately victorious on appeal as well. And the same thing with the state cases. I don't want to spend your money. I'm in private practice. I think you need to be funding public safety. I think you need to be funding core functions of government. But when it comes to chilling Kansans' First Amendment rights, I think that it's time for thinking outside the box. I've listed just a few things that came from my testimony in following up on the substantive law after you all passed major procedural reforms in 2023. Most of these were listed in my interim committee report, hoping that you do it last year. We will have thoughts on how you fix coordination, how you fix giving the name of another, or how you fix PAC, the major purpose to bring it in line with First Amendment and 10th Circuit precedent principles. The one thing I'd ask you to just think about until the next hearing on this is enforcement. I'm a county attorney. I just started my third term, reelected, prosecute everything from speeding tickets to first-degree murder. And here we had capital murder in Shawnee County. Prosecutors know how to do this. The Kansas County and District Attorneys Association knows how to prosecute crimes. The feds thought they knew how to prosecute campaign finance and wire fraud type crimes, but that's what they do all day, every day. Do we really need 2 or 3 or 4 bites the apple for an administrative agency to be kind of the Keystone Cop prosecutors when these are already misdemeanors? So I'd ask you, what is the executive branch? Who should be enforcing these laws? And is it a bureaucratic agency that needs to tie us up for 3 years on these cases, churning $85,000, $100,000 worth of fees, just chasing our own tails, trying to bring reason to it? Is that the best way to regulate? Thank you, and I'll stand for questions.
Are there any questions for Mr. Nye? Chair recognizes the ranking minority member.
Thank you, Mr. Chair, and thank you for the testimony. Very informative, and it's obviously there seems to be a need for us to dive in this and get more detail. But you said something that I found interesting. You said this used to not be a problem, but it is definitely something today. And I was wondering, and maybe you covered that in your presentation, but what changed?
What changed is the way in which statutes are interpreted. Mm-hmm. And when there's a new interpretation, what do you do about it? This agency has advisory opinion authority. They also have rules and regs authority. A good example is just earmarking. Mm-hmm. That's what the big investigation starting in 2022 was all about, was whether you could have pass-through schemes, so to speak, from a candidate or a donor to a PAC to a political party, and then ultimately to another political party or county party or something like that. That whole idea. And whether you want to regulate that or not is up to you. We pointed out that this is ubiquitous activity happening on the Democratic side, on the Republican side. We don't think that the law that was designed to do something completely different covered earmarking. The legislature has yet to speak, and frankly, the commission hadn't spoken. There was no rules and regs saying this. There was no advisory opinion. They didn't issue a single advisory opinion in 2023, and that came up in our district court hearing. And that was actually mentioned in the district court opinion that I've linked to here. It's just a fair notice of what is the law. And so it's really that making law by enforcement, by subpoena, by complaint, and then having to actually litigate it versus giving all Kansans notice of what's going on. And that happened with the PAC definition. My client's Fresh Vision OP is made up of 3 members, a Republican, a Democrat, and a Libertarian. And they just wanted to advocate regarding chip and seal in Overland Park, and they got lit up and called a PAC by the Governmental Ethics Commission, spent $30,000 of their own money, and then 2 years later were victorious in court. They won't get all of that back, but how much are you going to make Kansans go through to defend themselves on making law by enforcement rather than providing clear laws and then asking the question of the agency, what are you doing?
So and one more, Mr. Chair, is, and my colleague mentioned it, but you said there was a person, Karen, or I'm not.
Carol Williams.
Carol Williams, okay. And when Carol was involved, things went well. Is that what I was hearing?
Yeah, I mean, I had cases with her as well. Mm-hmm. And there was a general culture, I would say, at least in speaking with other people in this dome, that it was, there was at least a reasonableness to it. And and I'd be happy to bring the transcript
No, it's fine. I just,
of her, well, I was just going to point out, of her expert testimony in the federal trial, that's public record, of how she described what her role was. And it wasn't a gotcha role.
appreciate that. Thank you, Mr. Chair.
Are there any other questions for Mr. Nye? Mr. Vice Chairman.
Thank you, Mr. Chairman. Thank you, Mr. Nye, for really very interesting testimony. I wonder if one of the questions that I would immediately have, and I think maybe it's part of the rub, is the earlier testimony about removing application of civil procedures to KGEC hearings. As far as the notion, my memory from 2023 was that there was a real concern because these are free speech related that we should be using sort of a higher level of procedure, like civil procedure, rather than just administrative law. And is that still part of the rub? I mean, I would take it from your notion that you would not want to have any more administrative procedures being, did we correct it enough in 2023? Or how would you describe that?
Yes, I haven't looked at the draft closely. I just got it today, but what stuck out immediately was wanting to strike out the provision that applies the Public Speech Protection Act to actions of the Governmental Ethics Commission. That's why we're getting our attorney's fees in Shawnee County District Court. That's your law. And it just says, if a lawsuit implicates First Amendment activity, you have to have a prima facie case. That's it. You just have to draw up a case that shows it's not meritless. And how we won on that was not only did it implicate and chill our rights, and we told Judge Watson, but it also is unconstitutional what they're doing. And she said, I agree. And so there's a sense in which, do you really want to continue to make laws to rein in this particular ethics commission and this particular way of approaching regulation in Kansas? Or is there some other way to do it just to let reasonable minds prevail? And if there's a disagreement as to whether something is illegal or not illegal, let us get to a jury trial a lot quicker. Don't make us live in purgatory for 3 years on a subpoena. This is all over a subpoena, which I assume you all don't want your entire cell phones regarding any text that you sent to any political actor in the state over the past 5 years, that you wouldn't just say, oh yeah, here you go, and by the way, here's my underwear drawer too. There's got to be some reasonableness, and that's what, frankly, in the public hearings on other cases, Judge Watson said is, it's undeniable that these are incredibly overbroad, these subpoenas. And so that's kind of what, I really just am shocked that they want to get rid of the Public Speech Protection Act because they lost, and now they just want to take away the tool for us to even push back on meritless cases. I'm kind of dumbfounded on that.
Representative Simmons.
Hello, sorry. So it sounds to me, thank you, Mr. Chair. It sounds to me a bit like, okay, in the judge's case, why is she saying they're too broad?
Well, the subpoenas themselves, I'll have to look if any of them are in the public record. They are embarrassing, obviously, because you've got every political associate you've ever known. And now all of them are tagged with ethics. You guys are dirty, rotten scoundrels because you're on a subpoena somewhere. But it was seeking tetrabytes of data for any communication with this list of 20 to 25 people, as well as, and remind me, any elected official, any candidate, successful or unsuccessful. And for some of their clients, that meant, I don't even know how we would begin to do document review on that. Many of those subpoenas are still kind of just out there in the ether, even though we changed the law. They haven't been withdrawn by ethics. And so I'm happy to come back to the committee with the district court judge's comments in transcript form if they're available. A lot of our cases were sealed until the moment of decision, and the judge said at some point she's just going to open them up. which I think would be, at this point, even though my clients don't want to have their name in the paper, at this point, it's more about the actions of the commission than it is about any investigation. And these are going back to 2018 and 2020 communications. So I guess it's more of a you read the subpoena, put yourself in their shoes. I mean,
That's what I was doing with my question, in fact. Firsthand, I mean, I think all of us in this room, if we've been doing politics for any amount of time, understand that often it is years in advance. They're calculating and thinking through. And so I suppose how would you articulate navigating that? Because it's a reality that I mean, I know myself 5 years ago, I have many texts that would be relevant to political ongoings now.
yeah.
So what?
Face that in federal court and other cases where that's a new strategy of public interest groups that actually sue, is to just light everyone's cell phones up and try to get your correspondence with lobbyists. And this is all First Amendment protected stuff that at least has a First Amendment privilege analysis that would be applied at some point. Our cases didn't even get to First Amendment privilege to actually go line by line through the subpoena, because the judge ultimately said, the way you're trying to interpret this statute is nowhere close to how it's been understood for 30 years. I mean, really quickly, giving the name of another, the whole point of that in the 1970s was, if I'm a boss, I tell all my employees to give to these candidates, and then after the election, I come back and pay them a bonus for that same amount. That's giving in the name of another. That's keeping my name off of a report. What the commission has done is they've tried to bootstrap in federal earmarking regulations that exist nowhere in Kansas, and say that even though my name's on a report, if I give it to a county party and there's some sort of understanding or advice or something like that, that the county party consider these candidates, that somehow now we're guilty of that misdemeanor. And so that's where I think, I don't know how to fix it other than to say, you got a problem, and I have to answer the voters when I file a case. I get thrown out of office if they don't like how I prosecute. There's no way to throw this prosecutor out of office through the ballot box. So just be careful how much power you give this commission. That's all I'm saying.
Well, for the record, I've always found the commission to be very helpful, but I appreciate you sharing your perspective. Thank you. Thank you, Mr.
Probably
Chair.
very good at keeping your head down. So good job.
Mr. Vice Chairman. Actually, I'm going to jump in line ahead of you. I apologize. I just want to clarify on this issue of subpoenas. What is if a candidate gets a subpoena in the middle of election year from the Ethics Commission, why might they not want to fight that subpoena?
Well, I have never received a subpoena from the Ethics Commission. Maybe I'm inviting one today. But obviously with an ethics tag, anytime you push back on something, leaks obviously in this building are one thing. Our judge in the district court case, she posted this sealed case order on the website of the Shawnee County District Court. She thought it was so significant of a public policy result or a public policy issue that dealt with all Kansans. She says, I had no intention of keeping my ruling from Kansans to understand what's going on here. Even though the rest of our pleadings and all that are still sealed, there's just a stigma. And I've spoken to the commission about this multiple times in public comment over the years to say, be careful how you do it. I mean, not filing a report 3 days late you're unethical. It's just this, and ethics comes from Chapter 46, that your gifts and your lobbying and all of that. Campaign finance is in Chapter 25, and it's just difficult to help navigate this for clients.
Sorry for cutting the line there, Mr. Vice Chairman. You're up.
Mr. Ney, one of your last suggestions is reconsider enforcement mechanisms for campaign finance and governmental ethics laws in Kansas, prioritizing the role of elected criminal prosecutors over administrative remedies. I mean, did we not already do that in '23, or we just didn't go far enough? Or, again, it's a little counterintuitive, the fact that you would prefer to have elected criminal prosecutors involved rather than just simply an administrative remedy. But you're saying that that actually would be preferable because it's more clear cut,
We already have jurisdiction. Mike Kage has jurisdiction over any campaign finance issues, that violations of the Campaign Finance Act. Most of the things that we're talking about are misdemeanors. The only thing that are not misdemeanors are 3 days late, you get a penalty. That's more like just a late penalty. Everything else that we've talked about, coordination, PAC, giving the name another. In my federal trial, it had to do with personal use of campaign funds. All of that, I mean, the feds turned that into a 26-count felony indictment because they just turned that into bank fraud, wire fraud, and money laundering for the same fact pattern. So I'm just saying you've got multiple layers of enforcement officials already that can do this. The most frustrating part is to be spinning our wheels in administrative bureaucracy with a commission that's trying to decide whether I have a right to depose the complainant or not, or to subpoena the entire investigatory file, or any communications that may be relevant to how they came up with this investigation in the first place. That's an administrative purgatory. I would much rather be in front of a district court judge who understands the Constitution, does this all the time with regard to civil cases and criminal cases, and I have a right to that stuff, and so it's just easier. It may be more severe. I don't think anyone's going to jail anytime soon for, these types of stuff unless you steal tens of thousands of dollars. But you already have that. So I'm just saying, do we really need 3 bites at the apple for the same conduct?
So I'd like to follow up on the vice chairman's question with a kind of devil's advocate question. This is inherently political. We're talking about political speech. And I think the reason that people set up the commission to begin with is you've got, the governor appoints some people, political people appoint the commissioners. And so there's some sense of bipartisanship in there. Nobody's getting railroaded by the Republicans or railroaded by the, and if you took that out and you had an elected prosecutor who is elected by Republicans or Democrats, aren't you inviting more political prosecution?
I guess it's 2024, 25 now. I guess I'm cynical that there's any perfect person out there that's not political. A prosecutor is elected to administer the law regardless of who's in front of them. And they have to answer to the people in a democracy. This commission functions like the Fed or the Consumer Finance Protection Bureau. It's this kind of weird independent thing over here, and we're somehow trusting this 9-member commission to pick someone and pick a staff that is not going to be going after one side but not the other. And I still don't have, to this day, I still don't have an answer of, A, I don't think anything the Democrats did in 2024 or 2022 and 2020 as far as victory funds moving money was illegal, because I don't think you've gotten around to regulating it. But we're standing in a closed hearing last March or April, and the Judge Watson asks, what's the difference between what the Democrats are doing and what you're alleging that these people did on the Republican side? And staff is trying to come up with factors, ad hoc factors in the moment to decide, well, this is distinguished over here. And our point was, where are those factors? You had all the time in the world or all the ability to issue an advisory opinion, a reg, go to the legislature and say, we think you should regulate this conduct. But the first time we heard about it was in a sealed proceeding where even those factors didn't apply favorably to the Democrat activity either. And so I guess I'm kind of past the whole idea that there's some ideal that we could have a non-political prosecutor. I think checks and balances is what the Federalist Papers said that we need, which is not only jury selection and be tried by your peers, but also ambition checking ambition. And as a prosecutor, I'm an advocate. I'm an advocate for justice, but if I get it wrong and they think I'm targeting someone because they're Republican or Democrat or Libertarian, then A, they can throw me out of office. B, they can appeal to the jury quickly, a lot quicker than administrative subpoena or administrative action. And C, there's multiple levels of a judge actually trying to apply the same principles to every case. And so I really, at this point, just don't think that we can expect politics to not be in it, because my clients have gotten burned.
Representative Simmons for a second time.
Thank you. I want to be just crystal clear. The discussion about changing the name of the KGEC, that's rooted in appeasing emotional sensitivities. You say it upsets people. I mean, can you elaborate on that? Does it have any kind of tangible consequence?
Representative Simmons, that wasn't his statement, that was my statement, and I didn't, to clarify, we had a discussion in the interim hearing about whether changing the name of the Governmental Ethics Commission might remove some of the stigma of being subpoenaed, because a subpoena is not a, is not a charge. And so that was a conversation we had, and I just asked the director about it, but Mr. Nye didn't bring that up.
Thank you for the clarification. I studied campaign ethics in my master's degree. That is the industry term.
Well, I mean, I'm subject to the disciplinary administrator, the Kansas Rules of Professional Conduct as an attorney. That's an ethics issue. And I think it should be an ethics issue, because we're dealing with fiduciary duty and all that type of deal. But I do think there's a distinction between failing to file your report for 3 days or 5 days or 30 days and stealing $100,000 from your campaign fund.
Are there any other questions for Mr. Nye? Okay, I've got a couple, Josh. I'm sorry. You're not getting off that easy. Okay, first of all, has any work been happening since the 2023 law to try to reach an agreement on these definitions and bringing some clarity to the law?
Yes, I think staff and I got together early on in 2024 after the interim committee, January, February, just to see what we could agree on. We did that successfully in 2023 on the procedural stuff and kind of came to an agreement on a lot of this stuff. A lot of that stuff is being, I mean, some of that stuff I can already see is being asked to be repealed. We tried. I think at the end of the day, we just see the world differently when it comes to regulating First Amendment conduct. You either have a presumption of, I mean, the First Amendment and case law already gives kind of a heightened scrutiny for this stuff. And so that's why it's easier to win these cases than it is a water meter case, especially when you've got kind of a enforcement approach that's very zealous. We've won 3 times now, or twice now. There's been a third win come out today, and there's a 4th case pending that we'll see what happens in that. I think it was determined, given kind of the lack of appetite for another fight in the papers regarding, whether I'm trying to get my clients off or he's trying to, prosecute everybody under this dome or whatever, just the vitriol that goes into those types of advocacy causes. There just wasn't a lot of appetite for that again. And we decided our clients can't wait, because they basically shut down their operations as the Overland Park 501c4. And so the result, even of a dismissal in front of the commission in 2022, the result was my people didn't want to speak. I think that's an unconscionable result. That even though we won, and even though the only thing we were required to do in that administrative case is agree in the release to not sue the commissioners personally, that's what they ask of us, as a condition of dismissing the case. They decided it's just not worth it. And do you really want Kansans of all political persuasions concluding it's just not worth it? I think the answer to that is no. I've I've had very good conversations with people on both sides of the aisle on this. The governor's office going back 2 years on this, and we've continued to talk about this. And I think there's wholesale agreement, and you can see this in the testimony of Will Lawrence in October of 2023, that he says, we just want to know what the rules of the game are. Don't move the goalposts after the game's been played.
Thank you. Are there any other questions for Mr. Nye? Okay, thank you for your testimony. Thank you for your time, and thank you for your passion on the issue. All right, committee, that concludes our business for today. I just want to give everybody kind of a heads up on what the next couple weeks are going to look like. So on Thursday, we're going to have Secretary of State Scott Schwab here to talk to the committee about his legislative priorities and whatever else he wants to talk about. Then really, I'm just waiting for bill numbers. We're going to get right to work next week on hearings on bills. If I can get the bill numbers, I anticipate that on Tuesday, we'll be looking at the was it RS 0410, which is the driver's license, the coordination between the DMV and the Secretary of State to identify non-citizens. And then on Thursday, a constitutional amendment to make it clear that only citizens can vote in the state of Kansas. And so I like I said, we got to get those through the, introduced on the floor, get bill numbers for them. So the schedule that may come out at noon on Wednesday may not reflect the bill numbers, is why I'm telling you this, but that's what we're going to be talking about next week. So I want to give everybody plenty of heads up if they, so they could spin up on the issue, take a look at the bills, and if, if they have people that want to speak to the, from the public that want to speak to those bills, they're prepared to be able to do that. Is there anything for the good of the order? Okay, seeing nothing, we're adjourned.